May please your lordship, yes. My lord, I'd like to mention item number 13 now, today's list, my lord, the hearing matter, my lord. My lord, I pray for adjournment for a week, my lord. I have already taken the consent from the other side also. Next week, my lord.
Mr. Bhattacharya, let the matter reach, will pass the order on your behalf, but let the matter reach at this stage.
My lord.
May please, your lordship, I discrepancy of item number 14 to 18, my lord. We require some more time to file affidavit. Petitioner advocate is here, my lord. We have taken consent.
This is the third time that the union is taking a
Last time
habeas
we
corpus. Last
Last
opportunity.
opportunity may be given.
Okay. What's the matter about, madam?
Matter is regarding the habeas corpus, my lord.
That's foreign nationals who are being detained
Detention of foreign
across the
nationals
state. But it's in relation to their detention conditions.
in Guwahati.
You haven't filed the affidavit.
No, my lord. I will file the affidavit within 4 weeks, my lord.
Within 4 weeks, what do you think?
Because my lord, it has come to
Nothing like that. Matter is of 2000 and you'll have to
20.
file it 4 weeks.
My lord, then 3 weeks, my lord. That has to come to from the Ministry of
Don't bargain. Give a date.
my lord.
Don't bargain.
My lord, today is first week of December, my lord.
Give a date.
My lord, 4th of December, my lord.
You file it on or before 1st of
First of
December.
yes, my lord.
We'll have it on 5th.
Yes, my
Last something I get to the Union of India. Respondents are taken. File your affidavit. Fail in which court shall proceed with the matter without any accept of the respondent's opinion. The respondents in media shall file their affidavits on or before 01/12/2020, serving copies of the same. The council for 02 2nd of placed on 05/12/2020.
Master, bless, my lord.
Very good.
I plead your lordship. Your lordship, I would like to mention item number 21 for adjournment. The engaged counsel for the matter is on medical leave. He recently went through a surgery and currently he is not in a state to speak.
Who is on medical leave?
Sarfraz Nawaz,
What's your good name?
S. Rahman.
Mr. S. Rahman, counsel for the petition. Welcome. On behalf of Mr. S. Nawaz, counsel today. That Mr. Nawaz, the learned counsel. Absent. By the letter of absence. 14. Medical ethics. Page 4. List of the Yes.
May
Oblige
please,
your
your lordship. My lord, item number 2, I may be allowed sometime to go through the record, LCR.
May I plead your lordship, item number 10, lordship.
Yes.
Our
Yes,
lordship,
yes.
leading learned counsel M. Hawk out of station, lordship, due to his serious illness. The matter may be fixed after 1 or 2 weeks, lordship.
Let the matter reach. Let the matter reach. Yes.
May it please your lordship. Lordship, I beg to mention item number 20 with the consent of the other party, lordship. Lordship, this matter was led by Mr. Nair. Since he got elevated, lordship, the client wishes to seek a new advocate in this matter, lordship. So some accommodation may be given.
Yes.
My lord, beg to mention item number 8 on research of my senior active request. For some personal difficulties, unable to appear today in the court. So matter may kindly be,
2017 matter. Let
Yes,
the matter
Lord.
reach. Let the matter reach.
all right.
Yes, you are seeking time, but thing is this, there is no Akalatnama, nothing.
Lordship, I am aware of that, lordship.
Copy is not been served. Tell us, what's your good name?
A Setia, lordship.
A. Setia. Full name?
Osajjo Setia, Lordship.
You have informed the others.
Yes, Lordship. Union of India.
Learned senior counsel. Appeared for the sole respondent. Comma. Mr. UK Nair. Comma. Who represented the said respondent slash applicant before the Central Administrative Tribunal, Guwahati and Guwahati. Be connected with number 040/00163/2020 has been elevated as the judge of this court on Friday, date of right. In view of the Mr. A. Setia, learned counsel. What's your full name?
Osajjo Setia, Lordship.
Osajjo Setia. Borua, full name. Learned counsel. Appearing for the sole respondent. Praise for some time to engage senior counsel. Behalf of the sole respondent. With the learned counsels for the appellant, sorry, petitioners. I have no objection. It is seen that impugn order dated 11/0/2021 passed by the Central Cat Guwahati in said ONM has been stayed by this court on 13/12/2021 while it's being notice to the sole respondent, which is still in force. The sole respondent shall make necessary arrangement in the matter. Even place this matter for hearing again on 7th of December.
Highly obliged.
Mr. Ali is here.
Lordship, at present he is not here, Lordship.
No, we wanted to know whether this was earlier Morigaon or Bokoni, because Jagirat
Oh.
has become.
Yes.
You are supposed to place us before the court.
I will call Mr. Lordship.
After some time,
Lordship.
Well, here Lordship has directed us to bring on record the action taken against the 4 police officials who were present in the car, my lord. What is the charge sheet? What is the inquiry conducted against them? They have given us the information that there have been some increment has been deducted
in respect of the officers, but the detailed records, the inquiry report, the charge sheet copies, I'm awaiting that. I have also talked to the SP, but they need some time. Lordship may give us 1 week time. We'll produce that.
Now, we also want to know
Lordship.
how you have come to know that the petitioner is the next of kin of the deceased.
Well, that is another information, Lordship has directed from the government to apprise. That information has not come. But in fact, while giving us the parawise comments, the petitioner has approached the Honorable Court by filing this petition. And while approaching, he has stated, otherwise there is no record in the parawise comments of the authority.
No, because we have seen that the authorities have considered him to be the next of kin.
But here
Right.
he has said that he is the father. He is the father of his son got he was the victim. Paragraph 2,
Software to 9. No, software to 9.
এটি এখনো এই আমি ব্যাংকে কইছো যে রকিবুল হোসেন সন্ন্যাস জাকির হোসেন কিন্তু এখন নিজে ইজল সোনামিয়া এই হেৰি কলগাছিয়া এখন নিজকে সান রকিবুল হোসেন বুলি কৈছে বাট এইবিলাকতো কিন্তু সানটো হেৰি আছে আমাৰ সোনামিয়া ইয়াতে কিবা আছে নেকি দেউতাকৰ নাম নাই এইখন কি
Mr. Nath,
Malad.
you have filed an affidavit.
We have filed an affidavit, Malad.
In your affidavit, please see the annexure 1.
Malad. Yes, Malad.
Kindly read it.
With reference to your complaint dated 30/10/2015, I am directed to say that the matter was considered by the Commission on 28/2/2018. The Commission has made the following direction. By its proceedings dated 17/5/2017, the Commission had recommended to the government of Assam to pay a sum of ₹1 lakh to the next of kin of the deceased Rokibul Hussain. The state was given 4 weeks time to submit the compliance report. Pursuant to the direction of the Commission, the Joint Secretary to the Government of Assam Home and Political Department by communication dated 31/2018 has forwarded a copy of the receipt regarding payment of ₹1 lakh to the next of kin of the deceased Rokibul Hussain. Since the recommendation of the Commission has been complied with, the case is closed.
So that's why I wanted to know from you,
The next of kin,
who is the next of kin?
correct, Lordship.
The Human Rights Commission did not specify to whom it should be paid.
To the next of kin.
You have released that amount.
Yes, Lord.
Then to whom? What is your finding?
itu naik apa boleh kau naik? Jadi kau ada publication ni, kau kau naik? Naik kau. But I'll get the records, Lord.
Please come to the postmortem report, that
Yes.
is 12 of the report,
Yes, my lord.
12A, the next page.
Well, atomic DNA nuclei.
Thus say the cause of death. 12A.
Yes, my lord. Opinion as to cause of death, my lord.
Hmm.
In my opinion, the cause of death is death of the person
was
was due to
massive
massive
Cranial.
cranial injury along with damage
posterior
posterior fossa of the brain. Oh, please call me on the person. Lordship. Approximate time since death is around 18 to 22 hours. Well, he jumped from the vehicle, Lord, the running while he was taken from court to jail. He jumped from the running vehicle and sustained injuries. नेक्स्ट किनो कॉपी तो आनी बोलेगा कोने दिसे ये तो होमवर्क को बोलेगा होमवर्क को प्लान दे करो কাগজখন দিলেই হৈ যায় আমাক ইনকেছ আহিছে নেকি ইনকেছ ৰিপৰ্ট বিলাক আহিছে নেকি এইটো ইমান হেৰি আছে নহয় সোনকালে ৰিপৰ্ট আৰু আছে তোমাৰ ফাইলটো লৈ আছো ইনকেছ কাগজখিনি দিছে নেকি ইনকেছটো দিছে এক লাখ টকাটো আপুনি পোৱা নাই সেই পাইছে নেক্সট অপশনখন আপোনাৰ আছেতো কোনে দিব এইখন আপুনি নেক্সট অপশনৰ বেচিছতে দিছে নিশ্চয় দিছে কিন্তু আপুনি নিদিলে কোনে দিব নেক্সট অপশনখন খবৰ কৰিব খবৰ কৰিব কিন্তু হেৰিখন ক'ত নেক্সট অপশনখন
Mr. Nath,
Hello.
when will you able to tell us? Please see the action taken against this four police personnel
but
and also about the payment of compensation
the
next of kin.
yes the Sonamia has received the amount Malad. We have the copy of the receipt money receipt Malad we have
But did you
Oh,
did any exercise prior to releasing this amount to the next of kin of the deceased?
next page Lordship will find the Sonamia has signed and taken the money This is the petitioner, my lord. I'll get that, my lord. I got that point, my lord. The next of kin documents, whatever they have given, I'll place it, my lord. Page 17, Lordship will find his signature in the petition, page 17. Electric clear of my key voltage, the next of kin or copy to letter, on the basis of which amount was reduced. The copy of the next of kin. ফাইলৰ কেৱল দিলেই হ'ল পইচা ৰিলিজ কৰাৰ সময়ত যিটো কপি আছিলে
Mr. Na.
Mala.
Purva. Please
Fine.
provide us a copy of that so-called,
This one, right?
because so-called that was issued
Lordship.
sometimes in December 2016.
Yes, Lord.
The first paragraph, second paragraph you will see.
5/12/2016.
That's right.
Lordship. Lordship.
When will you file your affidavit?
But along with the documents, Lord. Lord, I need 1 week time, Lord.
Give us a date to file by.
Lordship. Lord, I will file by Tuesday next, Lord. By 21st, kindly give me time till 21st, Lord, for filing the affidavit. Lord.
Mr. D. Not. Correct. Senior government officer. Preparing for the state response. Praise for some more time. 5. The affidavit pursuant to the order with 9/10/2023 to which the Direct Council for the petitioner has submitted. List on. Twenty-fourth.
Lordship.
In the meanwhile, the state respondents shall file their affidavit as the record idea on 09/8.
Obliged, my lord.
But this show cause notice, copy of the show cause notice in the affidavit I'll file or not.
And also to tell us whether the, because we have not seen that order, the NHRC's order, whether it was forwarded to Mr. Alim or not, to the Tsunami or not.
Mala.
Yes, my lord.
Yes, LCR. Yes, Mr. Uddin.
Lordship, I have gone through the judgment, my lord, once again, my lord. So far, my lord, the finding recorded in, my lord, the point number 3, my lord, regarding exhibit 1 and 2.
Where is your written statement?
Yes, my lord, written statement in,
Have you annexed?
no, my lord, Lordship may kindly record page 41. Record, my lord. Notice to clear.
Yes, Mr. Kesuddin, what is your
Lord.
submission here?
My lord, so far, my lord, the finding recorded for exhibit 1 and 2. My lord, regarding the voter list of 1966 and 1970.
Hmm.
My lord, is the voter list pertaining to the in one her grandfather name appeared, my lord, and another voter list exhibit to 1971, my lord.
Hmm.
Her father name corrected name appeared there, my lord. But the learned tribunal, my lord, the finding is something else, my lord. Regarding age and her mother name is not appeared, my lord. And also, my lord, regarding exhibit 2, 1971. This finding is not correct because in 1971, exhibit 2, my lord, her father name appeared.
Hmm.
But the finding of the tribunal is, my lord, that her father name not appeared there. So this is, my lord, prima facie incorrect, my lord. And so far, my lord, regarding the discrepancy in the name and age, my lord,
Hmm.
this honorable court, my lord, in the judgment, my lord, held that this is not because this person are the not the author of this document, my lord. So this can be ignored, my lord.
Good.
So far, my lord, regarding the exhibit 3 and 4,
Hmm.
this is relating to, my lord, one, my lord, petitioners.
Hmm.
Petitioner name appear along with her spouse, my lord.
Hmm.
So remain, my lord, exhibit 5, my lord.
Hmm.
Which is, my lord, a linked document, my lord. And this document regarding this finding, my lord, I am allowed to read, my lord. Is the certificate of residency issued by OP by the government Gaura of her parental village.
Hmm.
The certificate of exhibit 5 has nowhere stated in the said certificate as to whether he knew the OP since his birth or as to for how long the OP DW1 is known to said Gaura. And as such, it is not enough in support of the OP's claim. So for this document, my lord, though it was exhibited, my lord, but it was not proved by calling the said Gaura, my lord. And in this regard, my lord, Honorable Supreme Court, in a judgment regarding, my lord, authenticity of the document, held that though this is not a document for, my lord, the citizenship, but it should be, my lord, regarded as a linked document. So this document is, my lord, already in record, my lord, and this honorable court in some cases, my lord, similar type of, my lord, remanded back the matter, my lord, without interfering, my lord, in the judgment, my lord, remanded back the matter for, my lord, reconsideration. I have some judgment of this.
Please give us the judgment.
Yes, my lord. And my lord, one regarding Kavinnama, my lord, already in record, my lord. This honorable court, my lord, similar situated, my lord, remanded back the matter, my lord. This was also a linked document, my lord. From the record, my lord, I have found, my lord, some, well, in her written statement as well as, my lord, deposition, she stated that her grandfather name is appeared in the voter list, 1966. Father name appeared, my lord. Mother name appeared, my lord, some time later, my lord.
You are relying on these judgments, right?
Yes, my lord. One is regarding discrepancy in the name and my lord, why father name and mother name not appeared. Another one is my lord regarding the my lord, power under section, under article 226, whether secretary can be issued or not, my lord. And another two judgment, my lord, regarding this honorable court, my lord, demanded back the matter, my lord, for the end of justice, my lord. And I have relied upon Supreme Court judgment, my lord. This is our High Court order, my lord. It is our High Court order. Yes. Rukjan Begum.
Rupchan Begum.
2008, 570.
18. 2018. Rupchan Begum.
2018,
কি হল পটিতে?
2018.
2018
হলো না? Well, this judgment, I think, 2018. Rukjan. আমার submission number 213.
মনিরুদ্দিন না? এটা কি হল?
Investigation age of Hattie.
Mr. Pine, have you gone through the?
Records.
Yes.
Records, my lord, I have learned it. My friend has gone through. Thomas has gone through.
Last,
Yeah, should they?
last.
As per your Kapilnama,
Yes.
you got married on 12th of December 2001,
Yes.
right?
Yes, my lord.
How come your name figured in the voter list of 1997 along with your husband? That's very.
1997. Total.
Mr. Pine,
Kindly go.
go to the written statement.
Yes.
Of course, this document you have placed it before the tribunal. But during the time of evidence, you have not placed it as an evidence, not as an exhibit. But it is here,
I will.
how come the voter list of 1997 reflects your name along with your husband? And really, there is.
No, that's
So in this time,
yeah. Nehra Begum is not my name. My name is Naima Begum. It is another one. Maybe, this is the daughter, sister of Abdul.
First time your name figured in the voter list in which year?
It's a 2005 man.
2005.
Yes, husband man.
Along with your husband.
Yes, ma'am.
Your name did not figure at village Dogijan. Why?
My lord, one voter list appear, but along with her father, but name is, my lord, appear as Naima Khatun. Some
After
days
marriage.
That
before
was
the
not
marriage.
executed. That was not executed.
That was not exhibited.
Whether the village headman was, the village headman adduced evidence.
No, my lord, that's why I, my lord, one order, the lordship. This court, without interfering in the, my lord, judgment, remanded back the matter and some direction is given, my lord.
What is your prayer read petition?
Well,
Did you pray for that? Look at your prayer.
lordship. That was not the prayer, my lord. But
Have you stated so at any point of time? Where you have stated so?
my lord, in this petition, I have not stated.
So
Proper finding is,
you are exercising what power as a jurisdiction?
my lord, that is, my lord, 226, my lord.
Two 26, but what 226?
To set aside and quash, my lord.
If it is certiorari, then what should be the order?
Lordship, my lord, regarding that, my lord, Kavinnama, my lord, one order I placed before your lordship, my lord. My lord, in WPC number 2018, my lord. This honorable court was pleased to pass an order, my lord, regarding considering the Kavinnama. No, Kavinnama is not a, but it is in the record, man, already. No. Yes, my lord, Rupjan Begum, it's 2018, reported in 2018. I have written 2008, my lord, only, my lord. It is reported in 2018. 1 SCC 578.
First of all, my lord, the fact in issue here is whether the petitioner could
18, my lord. Yes, ma'am.
2018 1 SCC 579. Yes,
Rupjan
Rupjan.
Begum, my lord.
First of all, my lord, my contention is that, my lord, with regard to the opinion, there is no error apparent from in the opinion. Because, my lord, even though we go to the evidence and, my lord, WS, we'll find, my lord, the petitioner has produced only one document is a link certificate. That is Gaon birth certificate. This is exhibit 5, madam. And that has not been proved. So there is a clear case, my lord, apart from other, my lord, discrepancies, name discrepancies, age discrepancies, and others, my lord. his main contention is his main documents, the exhibit 5. And it is clear, my lord, exhibit 5 is not proved. It is admitted position that exhibit 5 was not proved by calling the writer of the murder document. So when the exhibit 5 has gone, my lord, there is nothing, my lord, to show that she is the son of my lord, she is the daughter of my lord Abdul Jalil or granddaughter of my lord this Sikandar. If that document is not there, there is nothing. And that document itself is not proved. That is the only link document, and that has to be proved. Otherwise, my lord, other aspects are there, my lord, I'll argue on that point. But first of all, my lord, he has to prove the link certificate. If link certificate is not proved, there is nothing. Secondly, my lord, he has now relying on that one Kabil number. That Kabil number was not exhibited, even though probably it was brought in the my lord notice during the time of WS, but he abandoned that plea because so he did not brought that evidence, that document into the evidence while my lord deposing before the court. So he did not exhibited the Kabil number, and so proof of question of Kabil number is not there. Even though he brought it in his my lord WS, but he abandoned the plea because what reason I don't know. He abandoned that plea in the my lord in his evidence. He did not brought any evidence to that effect, my lord. Probably the Gaon certificate is issued by some other village from some other village, my lord. Some Sherlock village, my lord. This
No, no. Yes, well, I have not annexed in my petition, my lord.
this is not the my lord. So that is the main issue, my lord. The fact that is the main fact, and from the facts, my lord, even though we are not actually, my lord, we need not go to the facts in issue. But even though we go to the fact, my lord, facts shows that the petitioner could not prove or bring any link documents to his father or grandfather, whom she claiming to be her grandfather or father, and who is, according to him, was there prior to 1971 in India. So before, that is the precise fact, my lord. Now, my lord, with regard to the fact, tertiary jurisdiction, because, my lord, it is clear, my lord, from para 112. I'd like to, my lord, quote the para 112 of the, my lord, the Muslim Mandal. Yes, my lord. No. First of all, my lord, 2013 1 GLT 809. No, my contention here is that, my lord, it is specific that this honorable court will exercise tertiary jurisdiction while taking up this kind of matters in this honorable court. That is in para 112. It is clearly said this honorable court not go beyond that, my lord. Para 112, my lord. It is 2013 1 GLT 809 Muslim Mandal. My lord, here it is clearly said 112, Article 226 of the Constitution confers on the High Court power to issue appropriate writ to any person or authority within its territorial jurisdiction. The tribunal constituted under the 1946 Act, my lord, the Foreigners Tribunal, read with the Order 1964, as noticed above, is required to discharge the quasi-judicial function. The High Court, therefore, has the power under Article 226 of the Constitution to issue writ of certiorari, quashing the decision of the tribunal in an appropriate case. So, our jurisdiction is, my lord, certiorari jurisdiction. So that is specifically. Thereafter, my lord, it is said in which cases the certiorari jurisdiction can be exercised. That is clear in para 112, madam. But recently, my lord, the Honorable Apex Court, I'm just referring under what circumstances certiorari can be, my lord, issued. This is reaffirmed by this judgment. Recently, on my lord, this is 2023, my lord. This is 2023 SCC online, SC 996. This is by Honorable Justice, Chief Justice, and my lord J.B. Parodiwala. In the judgment, my lord, your lordship will find from para 50 onwards, so detailed discussion with regard to the, my lord, this is with regard to the, my lord, Central Council of Research in Ayurvedic and other process, Bickerton Das and others. That was with regard to the, my lord, the administrative tribunal's order. The High Court interfered. Then, my lord, Honorable Apex Court says no, my lord, you cannot. What you can do in the certiorari jurisdiction. This has been details. There is a details discussion. Here, my lord, may I read the 2-3 paragraphs of the, my lord, judgment. Paragraph 51, it is clearly, my lord, paragraph 51. Two cardinal principles of law governing exercise of extraordinary jurisdiction under Article 226 of the Constitution, more particularly when it comes to the writ of certiorari. The first cardinal principle of law that governs the exercise of extraordinary jurisdiction under Article 226 of the Constitution, more particularly when it comes to the issue of writ certiorari, is that in granting such a writ, the High Court does not exercise the power of appellate tribunal. It does not review or reweight the evidence upon which the determination of the inferior tribunal purports to be based. It cannot, my lord, it is clearly said, not review or reweight the evidence what the tribunal has found. But it demolishes the order which it considers to be without jurisdiction or palpably erroneous, but does not substitute its own view for those of the inferior tribunal. The writ of certiorari can be issued if an error of law is apparent on the face of the record. A writ of certiorari, being a high prerogative writ, should not be issued on a mere asking. So that is clear, my lord. We are not here to go to evidence. We have to see whether there is error apparent on the, my lord, or there is the court tribunal has gone beyond jurisdiction. So in the present case, my lord, there is the tribunal has not gone beyond the jurisdiction, nor it has committed error apparent in law. Only 2 points on the basis of which the High Court or Supreme Court may interfere under certiorari. Then it is stated, my lord, paragraph 52. The second cardinal principle of exercise of certiorari jurisdiction under Article 226 of the Constitution is that in a given case, even if, say, some action or order challenge in the writ petition is found to be legal, even though, my lord, it is found to be legal, my lord, and invalid, the High Court, while exercising its extraordinary jurisdiction thereunder, can refuse to upset it with a view to doing substantial justice between the parties. Even though, my lord, it is found to be legal, the tribunal's opinion is found to be legal, then also, my lord, it may refuse to upset the same order. And then it is said that the High Court, while exercising its jurisdiction, thereunder can refuse to upset, even though the order is, my lord, illegal, found to be legal, it with a view to doing the substantial justice between the parties. So that is clear. Another aspect, my lord, here it is discussed, paragraph 53, my lord. The essential feature of the writ of certiorari, including a brief history, have been very exhaustively explained in B.K. Mukherjee. That is there in, it is said, in writ in the nature of certiorari could be issued in all appropriate cases and in appropriate manner, so long as the broad and fundamental principles are kept in mind. The principles were delineated as follows. But here it is clearly said, the granting of certiorari, the Superior Court does not exercise the power of an appellate tribunal. It does not review or reweight the evidence upon which the determination of the inferior tribunal purports to be based. It demolishes the order which it considers to be without jurisdiction or palpably erroneous, but does not substitute its own views for the those of inferior tribunal. The supervision of the Superior Court exercised So writs of certiorari goes on 2 points, as has been expressed by Lord Samonin King versus so and so. In the area of inferior jurisdiction and the qualification and condition of its exercise, the other is the observation of law in the course of exercise. Certiorari may lie and is generally granted when a court has acted without or exercised its jurisdiction. Well, then it is the TC Basapa has been relied on. Then one thing the court has clearly said, after discussing the judgments of the earlier judgment, the court has stated by the apex court. The court explained that a court which has a jurisdiction over subject matter has jurisdiction to decide wrong as well as right. That means when the tribunal has the jurisdiction to decide wrong or right. And when the legislature does not choose to confer a right of appeal against the decision, it would be defeating the purpose of policy if a superior court were to rehear the case on the evidence and substitute its own finding in the certiorari. Yes, yes, madam. There is judgment of this honorable court, madam. First,
And the writ court is not the appellate court. So whoever fails to do that, only the duty of the court in exercising the power of certiorari against the order of the Assam Board of Revenue. The court is only required to find out whether the order is bad, good, or in violation of the law. That, if you can, anyone can find out. It's a very old judgment of Justice B.K. Sharma.
I can find it out.
But this is an order against the Assam Board of Revenue.
Yes.
Similarly, you will also get an order of Justice Sharma against the order passed by the Assam Administrative Tribunal. But I specifically remember with regard to an Assam Board of Revenue order, he has specifically mentioned. Yes,
Then, my lord, there are
this
numbers
is
of,
2023 SCC online,
yes, ma'am.
SC 996, right?
Yes, yes, ma'am. It is your lordship may, it is para 50 onwards. It is discussion is there. Even in this case, my lord, it is said that in case we can go to the records of the tribunal only and we can call for the records, and we can based on the records of the tribunal. That is there, my lord, here in this para 57.
No, that is, the calling for the record is also there are judgments of the Honorable Appellate Court only to verify
Yes,
whether it
that
is
is-
error and apparent on the face of the record.
that's why, my lord, it is relied on, the same judgment is relied on here, that we can call for the record, so you can verify the record, that purpose. So this has been reaffirmed, the same principle, and this honorable court in this case, my lord, Muslim Mandal, and numbers of cases I can produce, my lord, numbers of cases it is state,
Is it Muslim Mandal or Muslim Mandal?
Muslim Mandal, my lord,
Don't
Muslim
pronounce it
Mandal.
wrongly.
There's numbers of cases, my lord, where it is clearly said, we cannot go beyond certiorari jurisdiction. In certiorari
So
jurisdiction,
that's
we-
what this court have been constantly telling from the very
Yes.
beginning, whether we have the power.
yes. And secondly, my lord, one judgment I would like to refer. This is 2021, my lord, 1 GLT 799. 2021 1 GLT 799, my lord.
2021
1 GLT, my lord.
799.
Yes, 799. This is Nilvan, Musammat Nilvan versus Union of India. It is in the, my lord, it is a foreigner case, my lord. Where the, my lord, here your lordship will find The issue there was, my lord, that the petitioner there, she want to bring, my lord, new evidence after the cross-examination is closed during the time of hearing in the tribunal. Then it was rejected by the tribunal. And then he approached this honorable court. There it was decided, my lord, your lordship, you'll find the para 14, my lord, it is clearly said. Why? Because new documents, new evidence, how can it be introduced, my lord?
Please
In,
read.
in the present case in hand, we find that petitioner is seeking to introduce evidence by recall of witness, which was already available at the time of when the defense witnesses were examined. Exactly same as the case, my lord. It is not that the documents, my lord, two documents which my learned friend want to introduce or examine were not there in the tribunal. Those were there, and it is their fault they did not adduce evidence, my lord. The documents as indicated herein above are neither new evidence nor sought to be introduced, nor new facts discovered subsequently. Thus, it is apparent that only after cross-examination of the witnesses, certain lapses in the evidence of the petitioner's side was noticed. The main purpose of the rule, my lord, this is rule
Order
to
47.
be enable the court while trying to case to clarify and doubts. This is, my lord, CPC provision has been quoted as per CPC. Also, my lord, even though we are not following the CPC, my lord, even though it is allowed, my lord, by CPC, even though it is allowed, but in that case, my lord, only documents or evidences which were subsequently discovered or new documents, then only it can be used. But it cannot be used for purpose of filling up, my lord, the fault, the lacuna, which the prosecution or defense has, my lord, failed to bring in the time of evidence. While trying in a case, it clarify and doubts which it may have with regard to the evidence laid by the parties. The said provisions are not intended to be used to fill up omissions in the evidence of a witness who has already been examined. If one requires any authority, the authority might not discuss. Then your lordship will find para 17. As the court is exercising supervisory jurisdiction and not appellate jurisdiction, no case is made out of the for substituting the opinion rendered by the learned tribunal with the view of this court. This is not a case where the learned tribunal has refused to admit admissible evidence or that it finds it dehors the evidence on record. So this principle, my lord, even though we accept, my lord, there is a provision in the CPC for introducing evidence, then also it cannot be used. Because which evidence? These are not new evidence. These were there in the.
Mr. Pine, there is another judgment by which that only not documents to be placed, it needs to be proved by the issue.
Yes, there are judgments on that effect, madam.
Give us that. Because the issuing authority needs to adduce evidence.
Yes, but there are judgments of numbers of judgment, madam, the defect.
No, it was on the basis of a judgment, relying on the basis of apex court judgment, initial judgment.
Yes, yes. And secondly, my lord, my learned friend has relied on the.
Mr. Gyasuddin, please take your.
Another issue, my lord, my learned friend is taking the benefit of, my lord, the Rupjan Begum. Want to take the benefit of Rupjan Begum. 2018 1 GLT, my lord, 1 SCC 579. But in Rupjan Begum, para 15 and 16, it is clear. Para 16, it is clear, my lord. Even though my learned friend is relying on the Gampura certificate, but Rupjan Begum relies on my lord, speaks about the my lord, GP certificate. Here in para 16, my lord, it is clearly that the documents which my lord friend is relied on, that has to be, my lord, verified in two stages. Para 16, my lord, the certificate issued by GP secretary by no means is proof of citizenship. Such proof will come only if the link between the claimant and the legacy person who has been a citizen is established. Here in this case, there is no established, my lord. The certificate has to be verified in two stages. This is not done, my lord. The first is the authenticity of the certificate itself, and the second is the authenticity of the contents thereof. The certificate, my lord, which has been issued by the Gaobra, the authenticity of the certificate has to be, my lord, verified by calling the evidence witness who has written the, my lord, the document. The latter process of verification is bound to be an exhaustive process in the course of which the source of information of the facts and all other details recorded in the certificate will to be ascertained after giving an opportunity to the holder of the certificate. So second, my lord, the authenticity of the contents of the document has to be proved by calling the evidence of the writer and by examining, my lord, the source of information of the facts which is recorded there in the, my lord, certificate. So in absence of, my lord, that source, on the basis of which the certificate was given, the certificate cannot be accepted as a, my lord, evidence for that purpose. So this is clear, my lord. Again, my lord, my learned friend has relied on that. That is, my lord, Basiron BB, that is 2018 1 GLT, 2018 1 GLT 372, my lord.
Yes, what do you want to show?
There in page para 30, my lord. My learned friend is saying, my lord, this argument is that and the voter list which is made by the, my lord, authority, my lord, it is not the, my lord, wrong committed by the petitioner. It is the wrong committed by the, my lord, the authority. So it cannot be said that it is, my lord, it cannot be accepted against them, my lord. It cannot be accepted, my lord. Here it is. Para 30, my lord. Reliance placed in this case is Abdul Matali, alias Abdul Matalab Mohammed.
Para 30, 30.
30. Can reliance placed in the case of Abdul Matle alias so and so can be of no assistance to the petitioner in as much as it has already been clarified by this court in previous decision that the said decision did not lay any law and was a decision confined to the facts and circumstance of the case. Regarding the discrepancies in the voter list which the petitioner contended were not her creation being entered into by officials of election commission and therefore should not be used adversely against the petitioner. Such contention is without any substance. The voter list were adduced as evidence by the petitioner himself to prove her case that she was not a foreigner but a citizen of India. Petitioner cannot insist that only that persons of the voter list which are in her favor should be accepted and those persons going against her should be overlooked. This is not how a document put forward as a piece of evidence should be examined. The document has to be appreciated as a whole. That is clear. So voter list they brought and they are relying on that voter list that I'm the daughter of so-and-so or my father name is so-and-so. My father was there in the voter list 1966 or 71. So if he's relying on that voter list, he has to rely fully. He cannot say that only this part which is in his favor should be accepted. On these are wrong and which are against him, this may not be accepted. Either it has to be accepted or it has to be rejected. It has to be appreciated fully. Regarding my lord, that apex court order on evidence. That is 2010 4 SCC 491, my lord.
2010.
4 SCC 491.
The writer of the document has to, or the
Yes, yes,
adjudicator
ma'am.
has to adduce evidence.
Para 31, my lord.
Please take it. You say 2008 4 SSC 491.
My lord, 2010. 2010 4 SCC 491. 'Relying on this judgment,
You have the party's name?
yes,
LIC of India.
LIC of India verdict, my lord. LIC of India versus Rampal Singh Bishen.
2008 4 STC
2010, my lord.
10.
Yes, ma'am. 2010 4 SCC 491. 2010 4 SCC 491. There are 25, my lord, it is seat. 25, 31. Here, in fact, my lord, the document was, though document was admitted, the contents of the document was not.
Okay.
So this honorable court also, my lord, which relying on that in numbers of judgment, your lordship may kindly,
Yes, yes. Yes, tell us.
this is, my lord, this is, my lord, WPC 3807 of 2016.
Then
And my lord, another, my lord, WPC 4512 of 2016.
Hmm.
There also the principle was accepted. And there are numbers of judgment. Right? So my contention is that, my lord, the petitioner has relied on only one document in the tribunal that is not proof. So if it is not proof, it cannot be accepted as a piece of evidence for linking herself to her projected father or grandfather. So failure, if as she failed to do so, well, the tribunal has committed no error apparent, my lord, while declaring her to be foreigner.
My lord. So for the first point, my lord, regarding the jurisdiction under 220, Article 226 of the Constitution of India, my lord. My lord, so for the finding recorded for the exhibit 1 and 2, my lord. My lord, from the face apparent on the record, my lord, this is not correct, my lord. So this is my first submission, my lord. Second, my lord, so for the, my lord, this exhibit 5 regarding Gaubra certificate, let me kindly see what the finding is. It is not the finding that that certificate was not examined by the Gaubra, but finding is that only the exhibit 5 is the certificate of residency issued to the OP by the government Gaubra of her parental village. The certificate of exhibit 5 has nowhere stated in the state certificate as to whether he knew the OP since his birth, or as to for knowledge of the OP is known to the state Gaubra. As such, it is not enough in support the OP's claim. So there is no finding that the Gaubra is not called or examined, my lord. So this is one aspect, my lord. Regarding my another, my lord, so I have already placed a judgment. This honorable court, my lord, WPC number 2131/2018. My lord, Honorable Justice, my Lord Koteshwar Singh and my Lord L.S. Jamian. Lordship, may kindly see the findings. Some of this I am going to read, my Lord, regarding this.
2131/2018.
Yes, my Lord.
Yes. No, you did.
Lordship, may kindly see from the para 27 onwards, my Lord. May I allow to read, my Lord, some para. Having heard the learned counsel for the parties on perusal of the material on record as well as finding arrived at the learned tribunal, we would like to give our opinion as follows. As regard rejection by the tribunal that the NRC document is not only legally permissible, acceptable document in the eyes of the law, and also a statement made by the learned counsel for the state that it is not admissible a document, and NRC document cannot establish the citizenship of a person. We are of the view that while it cannot be relied upon as the basis for claim citizenship, it may have some relevance to establish the fact that the certain person named in the NRC document did live in the state of Assam at the relevant time, as otherwise how the name of a non-existent person can be included in the NRC unless it has been fraudulently inserted. My lord, second may be important for me, my lord. As regard the observation made by the learned tribunal relating exhibit 1, 2, and 3, which are voter lists of 1966, 1970, and 1985, that the person whose name appeared in the exhibit 1 voter list 1966, exhibit 2 voter list of 1970, along with the proceedings father and mother, did not appear in the exhibit 3 voter list of 1985. It cannot be a ground to ignore the relevancy of the said exhibits inasmuch as the said voter lists are in respect of village, same village, police station, subdivision, district respectively. It may be noted that certified copies of the electoral rolls exhibited are not the complete list. They are merely the extracts of the relevant part of the voter list showing the names of person who the proceeding considered relevant. Typically, proceeding before the foreigner tribunal, the proceeding seek to refer the names of person who the proceeding claims to be parents. It also cannot be denied that the state has an easy access to the voter list, and once the proceeding disclose the particular voter list as the basis of his claim, nothing prevents the state from verifying the same. Thus, merely because the name of other relatives are not shown in subsequent voter lists will not render such subsequent voter list suspect or irrelevant, so long as the names of the projected parents are shown in the same village as in the present case. The name of Innus Ali as son of so-and-so appear in the voter list of 1966 and 1970 and in the voter list of 1985. Yusuf Ali Talukdar as the son of late so-and-so. In the present case, though, there appears to be slight difference in the name of the projected father as mentioned above. In our view, the same is significant as the said name appear in the same village of Dumuria, part 3. Similarly, the proceeding stated that his name has been shown as Abbas Ali, son of Yusuf Ali, in the voter list of 1989 in respect of the same village, Dumuria, part 3, and the name of the proceeding is again shown as son of Abbas Ali Talukdar, son of Yusuf Ali Talukdar, in the voter list of 1997 in the same village, Dumuria, part 3. So, are the said names recorded in the voter list of 2005, 2008, and 2014 in the same village of Dumuria, part 3. The variance in because the addition in the surname Talukdar, the remaining names being same, but it is also noted that the names of village and the subdivision district remain the same. The fact that name of the proceeding projected father was shown consistently in the aforesaid voter list in respect of the same village would lead credence to the claim to the proceeding that his father was indeed a voter list of 1930, which substitutes his claim that his father as an Indian. Well, second part, the learned tribunal appears to have laid great emphasis on the describing the age of the projected father of the proceeding. Such discrepancy in reflecting the age in the voter list is not uncommon and cannot be said to be significant in the nature, and perhaps can be ignored inasmuch as in the present case, the name of the voter who proceeding claims to be his father along with the name of grandfather consistently appear in the same village and constituency. The learned tribunal did not appear to have considered all these aspects that the proceeding is also a resident of the same village but true and his projected father along with the names of the father also shown the same resident of village so and so so and so. So my lord, these are the my finding regarding the age and my lord the name has why. My father name is my lord this is sorry my lord, Abdul Jalil. Yes my lord. His name appeared in the voter list of 1971. My lord, he is still alive, my lord, as per my information. Yes, my lord. '28. Plus, yes, ma'am. Yes, my lord.
Yes.
Yes, my lord. Eight. Yes. Plus, 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 plus. But 1971 voter list is there. Plus. That's yes, yes, my lord. But look, this is Gabra certificate. That was my lord fault of that problem. But what is the finding recorded in the my lord lord. Lord. But my lord, only my humble prayer is that my lord, my lord, only humble prayer is that yes, Lord. Record. My lord, my humble prayer. Lord. As per section 9. But whatever, my lord, this document is on the record, my lord, and because, my lord, the tribunal, my lord, so far by jurisdiction of the tribunal, my lord, it is the final, my lord. There is no appellate authority above the tribunal. So, my lord, considering this aspect of the matter, my lord, so for the end of justice, Lord, and my lord, similar, my lord, our coordinate when I have, my lord, referred the judge order of this honorable court, my lord. Lord. So my
Yes. But, I have a copy, but it's not. Your lordship can take this. Copy. I have another copy, madam. Yes, madam. Probably it came in type law.
Apply, Your Lordship.
Morrigaon was a constituency, my lord. There is no instruction, but they have said that these documents are correct. Correct.
মানে 14 থেকে
Forty-nine.
Hmm.
49.
Down. Yes.
Yes.
Publisher, Iman Parikh. That has to be there. And when it is published, that has to be there. For Iman Parikh. No problem. Yes, that's it. Iman Parikh and Iman Parikh.
Give me some time, I will verify. Hello.
My lord, may I kindly pass over the matter for the time being, my lord. Senior Agent Legs in court number 18.
That instruction I have not taken, Lordship. Lordship. Yes, Lordship. Add two, Lordship. I will take. Lordship will find the impugn order at page 30. 4/12/2016. New document, I could not able to collect notes.
No, link.
Link document notes. 2005 voter list note. At page 23. Sorry. At page 23, yes, Lord. Nikunj Bihari Devnath is my father and Ranjit Devnath, me. Particular ethnic group. Annexure 3, page 18 will suffice, Lord. That my father was granted rehabilitation. That time I was aged about 25 years. I was aged about 25 years. There may be typographical mistake, Lord. Even then, if your lordship comes to page 18, this is the letter from the Undersecretary to the Government of India. It is there, Lord. Then I will try to get his school certificate, Lordship. Yes. I will have to take instruction, Lordship. Or the school certificate, Lordship. Nikunj Bihari Devnath. In written statement at page 26, Lordship, at page 20. But at page 29, affidavit he has shown Ranjit Devnath is a son of late Nikunj Bihari Devnath. Yes. Sure, yeah. Yes. Delta might have been remanded back for question. But if your lordship comes to page 18, this is the letter from the undersecretary lordship. Very cool. Come on. Very cool. Yeah. Very cool. Copy मिले तो Lordship. School living certificate, copy of the voter list of 1970 of his father, Lordship. Lordship. Then annex of 7 school living certificate of the petitioner, Lord. Page 15. Lordship. Exhibit 1 is the voter list of 1966. Exhibit 2 is the school certificate of the father of the person. Lordship. Get to the here I am not the next lordship. That one.
Grandfather. Grandfather.
And the school living certificate of the proceeded father. Then lordship at page 26 is the school living certificate of the petitioner. Where is the petitioner, lordship, Milan Devnath. And linkage is their late Forest Devnath. Twenty 2012. Page 26, lordship. But the order it is being stated regarding this
Record
exhibit.
lordship is not exhibited. Death certificate. Data confirm করেছে। এটাকে তারপর কি করবে?
These are the sufficient documents to prove that he is an Indian lordship. Here I have the next lordship. During filing of the return statement, it was misplaced somewhere. Subsequently, I could manage to collect it. Yes, sir. 6/1/1966. 1970. There is an overwriting lordship, 6/1. No. At page 27, this is the electoral roll of 2015. But my name appears, and my father name Forest Devnath also appears. Forest Devnath is my father. Yeah. Page 21 is the Forest Devnath voter list of 1977. I cannot lie that my father is so and so.
Lordship, Lordship. I did document. He has to establish his playing lordship.
General lordship,
With
what?
his project, no lordship. Only school certificate is remaining here, lordship. And school was established in the year 1970, and school certificate was issued in the year 1966, lordship. Apart from that school certificate was not proved, lordship. So this document has no value.
Generally, we do not keep the voter list lordship. After casting vote, it's going.
Proof it no total.
27.
No, lordship. Yes, lordship. And that can be one of the reasons, lordship. And others, lordship, mere enrollment in the name in the voter list, lordship, not a proof of citizenship. Lordship. So, Lord,
Right. And Lordship, eh, and Lordship, in 2005, Lordship, his name first time appeared, Lordship, at the age of 20 years, Lordship. But Lordship, if we see the affidavit, Lordship, at page 12, Lordship, in the year of 2017, Lordship, he was aged about 37 years. So if he's 37 years in the year 2017, then his name should first time come in the voter list of 1998, Lordship. But and Lordship, age is also not matching, Lordship, in this voter list. Lordship.
Every voter list there is available in the age. That cannot be a ground.
And nice. Also, if you have Lobo brand. Lordship, in the first case, Lordship, in the first case, Lordship, Lordship, already law has been settled regarding that, Lordship, petitioner proceeding could not go beyond pleadings, Lordship. And in the WS, Lordship, he categorically stated that he is the father of, he is the son of Sodoy Devnath or Sodoy Saran Devnath. Yes, Lordship. Yes, Lordship. Yes, Lordship. Lordship,
Item number 5, what do you have to say?
Lordship has asked regarding page number 27. Lordship, by this voter list, is there any link is established or not in respect of the petitioner, Lordship?
Mr. Thor is saying that it is the connection.
No, Lordship.
So that his father,
Lordship will kindly see Milan Devnath is a sole voter, Lordship, in this voter list, Lordship. Milan Devnath is a sole voter in this voter list, Lordship. And regarding Paresh Devnath, projected father of the petitioner, Lordship, there is no description about the Paresh Devnath, Lordship. And Lordship will kindly see page 23. Page 23, Paresh Devnath, son of Rampiari Devnath. Here, and earlier, Lordship, page in 1970 voter list, all other voter list, Lordship, Paresh Chandra Devnath, son of Pyari Mohan Devnath. So Paresh Chandra Devnath, son of Pyari Mohan Devnath, or Paresh Chandra Devnath of Rampiari Devnath, is they are same person or not? That pleading is not there in the WS, Lordship. More so, Lordship, regarding Lordship, regarding mother's name, Lordship, regarding mother's name, there is no explanation, Lordship, who is the mother of the Milan Devnath, Lordship. Who is the brother of the petitioner, or Lordship, who is the other family members of the petitioner, Lordship. There is no explanation regarding that, Lordship.
And Lordship, although petitioner trying to link up himself with Forest Devnath by this voter list, Lordship, Lordship, there is no explanation in the WS, Lordship, what happened to his father, Lordship, why his name not enlisted in this voter list, Lordship. So, Lordship, tribunal cannot ascertain that Forest Devnath and Forest Devnath of 1970 voter list is the same person or not, Lordship. There is no feeling regarding that. Lordship, may I submit, Lordship?
Yes, please.
Lordship, para 26 of the Sarbananda Sonal 1 case, Lordship. Lordship, there is good and sound reason for placing the burden of proof upon the person concerned who asserts to be a citizen of a particular country in order to establish one's citizenship. Normally, he may be required to give evidence of his date of birth, place of birth, name of his parents, their place of birth, and citizenship. Sometimes the place of birth of his grandparents may also be relevant, like under Section 61A(d) of the Citizenship Act. All these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. After he has given evidence on these points, the state authorities can verify the fact and can then lead evidence in rebuttal if necessary. If the state authorities dispute the claim of citizenship by a person and asserts that he is a foreigner, it will not only be difficult but almost impossible for them to first lead evidence on the aforesaid points. This is in accordance with the underlying policy of Section 106 of the Evidence Act, which says that when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. Lordship. Here, Lordship, petitioner is silent regarding the name of his mother, Lordship. And not a single document has been placed before the tribunal, Lordship, in respect of his mother. And by this voter list, Lordship, Milon Devnath cannot establish his link with his projected father, Lordship, Forest Devnath, Lordship.
Legacy comes from the father and grandfather, Lordship, not from the mother.
Parent. In absence of Lordship, father's name, age, and other description in respect of this voter list, Lordship, that cannot be accepted as a linked document, Lordship.
Who is Rampiari Devnath? Who is Rampiari Devnath?
It was a mistake by the election officer. It will be Pieramon. It should be Porachalo Devnath. Instead of they have written hearing on Devnath. And I cannot be access to the voter list. Rampriyari Devnath. Rampriyari Devnath is the father of Poresh Devnath.
Pyari Mohan Dev.
Hmm. Page 17 is the voter list where my grandfather's name appeared. Hearing on
When did your father expire?
father, lordship, prior to 2012.
Your father expired?
Prior to 2012. Or yes,
When?
lordship, the certificate which has been issued by the school, it says that late Poresh Devnath, lordship. When he actually died, I'm not able.
That explanation is also not there, Lordship.
But
The
in,
school certificate you have not proved, not
Yes.
exhibited.
not may not be, lordship, but here it is written late Poresh Devnath.
In your written statement where you have stated that you have studied in Kalachandpur, Narayanpur ME School,
That I have not annexed in this.
have you stated so?
That I have not annexed in the repetition, Lord.
Have you stated in your written statement that you studied in Narayanpur ME School?
The written statement in this case was not supplied to me, Lord. It's what I could not annex, Lord.
What have you?
Mr. Sharma, anything to add?
Lordship. The document placed by the petitioner by this document, Lordship, link is not established, Lordship. So,
So according to you, link document not proved.
yes, Lordship. By this footer list also, link is not established, Lordship. And apart from that, there is no document, Lordship, to prove his citizenship, Lordship. Apart from that, there is no document, Lordship, to prove his citizenship.
What about 2015 voter list?
Yes, Lordship. I have already submitted, Lordship, regarding Lordship. This your Lordship may not entertain this voter list as a link document because, Lordship, in absence of any description in respect of Forest Devnath, Lordship, there is no description who is Forest Devnath, Lordship, who is the son of who is the father of Forest Devnath, Lordship. Regarding age, Lordship, age is also not mentioned, Lordship. Forest Devnath. And this Forest Devnath and 1971 voter list Forest Devnath, are they same person or not? It cannot be a certain, Lordship.
Page 17, the voter list.
And 23, page 23, Lordship. I have already submitted, Lordship, regarding Forest Devnath, son of Rampiari Devnath. And there is no description, Lordship, regarding this Paresh Devnath and earlier Paresh Devnath is same person or not, Lordship.
Page 17, voter list of 1970. Paresh Devnath, P.R. Mohan Devnath, father. P.R. Mohan Devnath, Deepacharan. There are linkages of my father with the grandfather.
That's all. Yes, it's a third place, Jala.
Page 17 is the voter list of the petitioner's father as well as the grandfather, Lord. Where the name of the petitioner father appeared as Paresh Chandra Devnath and son of P.R. Mohan Devnath and P.R. Mohan Devnath Deepacharan. So there is a linkage between the Paresh Chandra Devnath and P.R. Mohan Devnath. And now, if the Lordship comes to this page 23, this is the Paresh Devnath, Ram P.R. Devnath. Oh, sorry. Page 27, Milan Devnath, Paresh Devnath. There is a linkage, Lordship. Paresh Devnath is linked with P.R. Mohan Devnath and Milan Devnath is linked with Paresh Devnath. There is a linkage.
Petitioner has to prove, Lordship, Paresh Chandra Devnath of 1970 voter list and name mentioned in Paresh Chandra Devnath in 2015 voter list, Lordship. They are same person, Lordship.
Please submit. 2000 voter list. Only Paresh Devnath.
2015 voter list. Paresh Devnath.
Chandra will make no difference. Chandra will make no difference because here it is maybe Chandra, Paresh Chandra Devnath, and here is Paresh Devnath. That does not mean that they are not the same person.
What I have observed, page 18 was not exhibited in the exhibited there in the tribunal. Instead of this page 18, my lord, he has submitted a legacy data of 1971. So page 18 was not there in the tribunal. Instead of that, one legacy data was submitted, my lord. There it is, Paresh Chandra Devnath, P.R. Mohan Devnath, age 28 is there. That is submitted.
Paresh Chandra Devnath.
Yes.
CHANDAR.
Yes. And son of P.R. Mohan Devnath, age 28 years in 1971 is there. So Paresh Chandra Devnath is a citizen. There is no issue on that, my lord.
But
So only question is, my lord, whether this Paresh Chandra Devnath, who is a voter in 1970 and who is also son of P.R. Mohan Devnath, aged about 28 years, is the Paresh Devnath of page 27 or not? That is the important issue, my lord. Because in page 27, my lord, the voter list of 2015, page 28, my lord, the vernacular, here it is only Paresh Devnath. Who is this Paresh Devnath? Who is the father of this Paresh Devnath? These descriptions are not there in the 2015 voter list. So in absence of all these descriptions, my lord, with regard to Paresh Devnath, we cannot accept this Paresh Devnath, father of Milan Devnath, is the same person who is there in the voter list of 1970 as Paresh Chandra Devnath, son of Pyari Mohan Devnath, aged about 28 years. Had in this voter list, my lord, 2015 voter list, this Paresh Devnath was also a voter, and his father's name was recorded as, my lord, Pyari Mohan Devnath, and age is, my lord, recorded with, my lord, corresponding to the 1970 voter list, my lord, then we can accept it, my lord, this is the same Paresh Chandra Devnath. But in absence of those descriptions in the 2015 voter list, we cannot say, simply due to, my lord, that this Paresh Devnath, father of Milan Devnath, is the same person who was a voter in 1970 as Paresh Chandra Devnath, son of Pyari Mohan Devnath, aged about 28 years. That is the issue, my lord, not the
Page 21, voter list of 1977. Here also Paresh Devnath, son of Pyari Mohan Devnath.
21 is not exhibited. 21, page 21, 23 are not exhibited in the tribunal, my lord. These were not exhibited in the tribunal.
The first exhibit is the date of birth of the petitioner.
Yes, my lord. Second is, my lord, the certificate of the father.
Voter list of
2015 voter.
2015.
15.
Then
Third is, my lord, the legacy data of 1971. That is legacy data, my lord.
here it is fourth.
Yes, fourth. Third is 2015.
Third, second is 2015. Third is 1966.
Yes, my lord. 1966. Then legacy data and Kasapatta of land.
Exhibit P, certificate of the father. Exhibit P.
From the records, what we have seen, that one Pyari Paresh Chandra Devnath.
Yes.
Let us be one Pyari Mohan Devnath, whose name figured in the voter list of 1966, was a resident of village Labok Grant South.
Yes.
Right.
Yes, ma'am.
As per the NRC document, one Paresh Chandra Devnath, resident of village Labok Ground South, was 28 years in 1971.
He was son of Pyari Mohan Dev.
Who has been shown as a son of Pyari Mohan.
Devnath.
Then one Kesapatta, issued in the name of Paresh Chandra Devnath. Without any date. Without any date. Was in the name of one Paresh Chandra Devnath. That's
Son of
Organa,
Pyari.
Baskandi, Moja, Lavok grant. But the village and other things not there. Then comes the school certificate of the projected father of the petition. He is from village Devipur, post office Shivpur, police station Lakhipur. But you have seen that Pyari Mohan Devnath or Paresh Chandra Devnath is the resident of village Lavok Grant South. But the school certificate exhibited before the tribunal by the proceeding, that of his father, specifically provides that this is a resident of, he was a resident of village Devipur, post office Shivpur, under Lakhipur police station. Now comes the birth certificate of the petitioner. Issued on, it was registered on 1st of February 1993, but it was issued sometimes on 14th of something 2005 or 95, something like that. It's not legible. But name of father is Paresh Devnath, mother is Himani Devnath. Resident of village Devpur, post office Shivpur. From the written statement and the affidavit, all along he is saying that resident of village Devpur, now joined as Lavok Grant South. Nowhere in the school birth certificate of the father of the petitioner or the school transfer certificate of his father, there is a mention that he belongs to Lavok Grant. That we have seen here. Then village is Devipur, not Lavok Grant. But a voter list of Lavok Grant South has been annexed to show. Mr. Dhar, there cannot be two. Had it been Devipur, the voter list would have been the village Devipur only. There cannot be Lavok Grant South. In your affidavit, while deposing before the tribunal, you have very clearly stated you are a resident of village Devipur. Notice issued to village Devipur.
Yes.
Question of Lavok Grant doesn't come here. Tell us.
There I have no explanation about it.
Hmm?
In this regard, I don't have
You
any
have not
explanation.
stated anything in your written statement.
Huh? It is a mistake committed by the electoral officer, where they have stated village Lavok Grant South.
So village Devipur and village Labak Grant has two different things. Tell us anything to add, Mr. Roy?
Nothing,
Anything to add?
no lordship. I leave it to your lordship.
Mr. Paying, have you gone through the order of the tribunal?
Yes, my lord, I have seen it.
Is it sufficient? Because in other cases, we are always saying it has to be a reasoned order, right?
Yes,
Do you think it's a reason?
simply, my lord, it cannot be said it's reason order.
Because it has to be a reasoned order. Exhibit 2, 3, 4, 5. Then proceeding file no documents for the period from such and such, no explanation for the same. As the proceeding could not be able to prove the case under section 9. Do you think it's a reason or?
Simply, it cannot be said, my lord, that it's a reason order. But but it is, my lord, the proceeding file no documents for the period from 1967 to 2014 and no explanation for the same. Hence, the prosecutor could not be able to prove his case under section 9. However, the details discussion with regard to the, my lord, exhibits are not there.
That's right. Tell us in that circumstances what we do.
Your lordship, if your lordship may, thinks, my lord, your lordship may remand this matter, remand for the passing of fresh order on the basis of materials available on record.
That's all. Completely.
Yes. Materials available on record. You may, my lord, we appreciate the evidence, whatever is there in the evidence, my lord, record.
We consider it's not a reason order without discussing the exhibits.
Yes.
The amount of discussions we had, there is no error of that in that.
Both the case, my lord, I have seen. Both the
But in
case.
the other case, one thing is very clear. Father,
Other is not different names,
so the
Yes.
explained by the
not explained. This case, your lordship may remand on that.
this case.
Item number 4 may also be remanded to, so that he
For
can.
what? For what reason? Only because we are remanding this, that also to be remanded? What is the reason for that?
Because
Your affidavit, your written statement, very clear.
In item number 4, page 27, the written statement, in paragraph 5, 6, 7, late Nikunji Obere Devnath has been spelled out. Name of the father of the petitioners, late Nikunji Bihari Devnath, but in paragraph 10, it has been Sadar Devnath.
This is your written statement.
Yes,
Who will know? You are the best person to know. And you have to explain.
but in paragraph 5, 6, 7, there is not.
That
Nikunji
is the
Bihari Devnath.
reason why you have appeared then.
I don't know why Sadar Devnath. Hmm? Oh. ওপরে দিলে একটু খুলে দেবো। এটা উঠিলে Oh, copy paste. Correct, copy paste. Page 29, the affidavit which I have shown in, they are Ranjit Devnath, age about so late Nikunj Bihari.
Maybe you have to explain who is 10, para 10.
Yes.
Your same stand is also in affidavit in evidence.
Nikunj.
Devipur and Labakren South are not same. Had it been the same village, it have been mentioned in your API card. You have also exhibited one document in the first case.
Okay.
All are from Labokran, not from Devipur. But notice was issued in Devipur, you have accepted it. What document is there, which you see that's in your read petition. Page number 34. That's your mother, right?
Yes.
See, village Devipur. So Devipur and that grant of South is not in the same village. WPC 5131 2017 dismissed. 5128 2017 will set aside this order. Refer the matter back for fresh judgment. Appeared before the tribunal by 6th of December.
Public.
Data file could-
Also, the senior election court number 24, my lord.
Let's start.
Also, we have filed the additional affidavit, my lord. That is not, we have already filed our affidavit, additional affidavit, my lord. That is not on record, my lord.
What for?
For bringing some documents, my lord.
Can you do it now?
We file on 9th, my lord.
Those additional affidavit, can you bring it to the court now? Hmm? You took leave from the court to file your additional affidavit.
No, my lord.
By which order?
By last order, my lord.
When did you file?
9th, my lord.
What is the filing number?
Number किती?
Do you have the copy of the affidavit?
I have,
Please pass. Evidence. 45 minutes. No, tribunal, no. Which one is correct? Which one is correct? The affidavit is correct or the documents that you have annexed are correct?
Prior to her marriage, she used to write her.
Verify. Why we have asked you that? Please verify. Read your affidavit, last paragraph, such and such, son of what? Son of what?
Har Kishore Das Talukdar.
Kindly read properly. See the spelling.
Har Kishore Das, my lord.
Or Kishore Das. Good. The
In
next,
somewhere, my lord, Hare Kishore Das is written.
son of
Hare Kishore.
Haro Kishore Das.
Yes, my lord.
Son of Haro Kishore Das. Then other son, Haro Kishore Das. And your sister, the present petitioner, daughter of Haro Kishore Das. So which one is correct? 4 different names. Which one is correct?
My lord, migration certificate, Har Kishore Das is there, my lord.
Hmm?
Migration certificate,
Hmm.
page 11, my lord. Har
What is the
Kishore.
link document with Haro Kishore?
Here, my lord, her mother name is there, my lord.
Hmm.
Shyamala Das Talukdar.
No,
Page
there
12.
is nothing.
Page 12.
Page 12 of.
This petition, my lord.
Hmm.
Her mother name is there, my lord. Shyamala Das Talukdar.
Page 12, yes.
Shyamala Das Talukdar.
Yes.
Har Kishore Das Talukdar, Shyamala Das Talukdar.
Then
And at page 22, my lord, voter list of 1993. Page 22.
Hmm.
Petitioner name is there, my lord, Dipali Rani Das. And second one, my lord, 1319,
total list of
1993, my lord, page 22.
1983.
1993, my lord,
1993. Total list. Okay.
page 22.
Ah.
Her mother name is there, 1319, my lord.
Hmm.
Here, my lord, it has been written as Syamal Das. It will be Shyamala Das, my lord. Wife
Shamal
of
Das.
Har Kishore Das, female, my lord.
Hmm.
And petitioner name is there, my lord.
It's not
Dipali
Har-
Rani.
you have typed it wrongly because in the original document that you have placed before the tribunal,
Yes.
it is Hari Kishore Das.
Hari
Hiralal
Kishore-
Das, it's not Har Kishore, Hari Kishore.
My lord.
Then Shamal Das.
Yes, my lord. Shyamala Das, actually.
You do not know,
Because he had it is written, my lord, female, my lord.
definitely
Female, wife.
that's you need to prove. Then again Hari Kishore Das. Okay. Then Himangshu Das.
Himanshu Das. Himanshu Das is the brother of the petitioner.
Hmm. Who is Dipali Rani Das?
Dipali Rani Das is the petitioner, my lord.
Then
Dipali Rani Das.
Hmm. Let us see your written statement.
Dipti Rani Das is the wife of the Hiralal Das. Her brother's written statement is, my lord, page 33. 33. Paragraph 7, my lord, is written.
You have exhibited only 3 documents,
My lord.
right?
Yes,
Your 1964 document of your projected father, voter list of 1993,
and migration certificate.
and after marriage of 2016 voter list. Any other exhibit you have exhibited? No. Right? Now,
Migration certificate has been, migration certificate, my lord,
migration certificate,
Very-
it's not there, not exhibited.
exhibited, my lord. At page 36,
36,
page 36. Exhibit 1 has been marked.
in your affidavit in evidence,
Yes, my lord.
where you have stated which para?
Page 36, my lord.
In your affidavit in evidence filed before the tribunal,
Tribunal, my lord.
which para?
Para 4, my lord.
Hmm.
That my deceased father name is enlisted in the migrated certificate as Horab Kishore Das Talukdar. Original copy of relief letter
Oh,
certificate.
that's exhibit 1.
Yes, my lord.
So there are only 3 exhibits,
Yes, my lord.
right?
And voter list of 1993 is exhibited, my lord, where my mother name and petitioner name and my mother name is with there, my lord.
That is the reason we are asking you.
Right.
If exhibit 1 is to be relied upon, then it's for Kishore Das Talukdar,
Where mother name is there, my lord. And thereafter in the voter list of
Shyamala Das Talukdar.
yes, my lord. And voter list of 1993, petitioners and petitioner mother name and petitioner name is
It is Shamal Das, nothing to do with Talukdar.
my lord. It's a spelling mistake, my lord. Because it ought to be Shyamala Das, my lord.
It is whose case?
My lord.
In the written statement, filed on 25th of January 2017, you have clearly stated that you are the daughter of late Haro Kishore Das. You have not stated that Haro Kishore Das and the certificate that is issued in the name of Har Kishore Das Talukdar is the same in one person. If you stated so. Your case is you are daughter of Haro Kishore Das.
Yes, my lord. Horab Kishore Das and
Where you have stated in your written statement. Have you stated in your written statement that Haro Kishore Das and Haro Kishore Das Talukdar and Shyamala Das Talukdar gave birth to 3 or 4 children, including you? Where is that?
no, my lord.
You have not exhibited your school certificate. Do you know why?
No, my lord.
Do you know why?
No, my lord. I don't trust it.
It was issued by whom?
School certificate.
School certificate you have annexed in your writ petition.
Yes.
You have stated in your affidavit in evidence. But you have silent with
Headmaster.
regard to that.
Headmaster, head teacher, my lord. Kalpana Bhatt. Head teacher of
Read the last paragraph of your written statement.
That the office family members for the purpose of livelihood used to reside sometime in Assam, sometime in Meghalaya, sometime in Tripura, and lastly, after death of the father, the family members permanently settled in Kachar at Silchar, Assam in the year 1993. Yes, because of this, the office father has no legacy data, any other old relevant document.
Now, just read your affidavit in evidence. There are three.
That I was born and brought up at Tripura state.
Born and brought up at Tripura.
Tripura.
How come you're schooling at Kachar?
She was born, my lord, but not.
Your case is that after the death of your father, you came to Kachar and resided there, right?
My lord.
Page number 29. What is the village of your voter list? Hmm?
Village Nutan Ram.
Hmm.
It was after marriage, my lord.
Hmm?
This is the address of a husband, my lord.
So how can it this has to be in terms of that certificate, this is address that was given in your school register. And you have not exhibited this, nor you have adduced the evidence of the concerned head teacher.
My lord may remand this matter, then
Why should
one
your
opportunity may be
case
given, my
you
lord,
should
because,
establish?
because some documents has not been annexed properly, the case was not conducted before the trial court, my
That
lord.
cannot be a ground. Today you have heard in the morning what
Because
Mr.
of the-
Payeng said, the recent judgment of the apex court.
Because of the fault of the advocate, my lord, the
Is it
petitioner
your
should
case
not
in
be
the
suffered.
petition
My lord,
where you have taken that ground?
no, my lord, that I have not taken, my lord.
Don't
But
blame
for
the
the interest of
advocate.
justice, my lord.
We are not sitting here for mandamus or anything else.
Lordship in the writ petition, my lord, can grant remand to the lordship has the power, my lord.
Let us assume that let us assume chances given to you to appear before the tribunal and to adduce evidence. What evidence you will need?
No, at least her brother's evidence could be.
You have not stated in your written statement that you have brother, sister.
That is why, my lord, written statement has
How
not been
can you go
properly
beyond
drafted.
written statement? Can you go beyond written? Now this certificate that you have issued, you have annexed page 31. What is the date given? The top?
28/6/2015, my lord.
And for your information, 28th of January, June 2015 was a Sunday.
Certificate may be issued
Why?
on Sunday or
It is
also,
an
my lord.
office. It's not a madrasa. It's a pachala.
Head teachers are staying in the schools, my lord, na.
Even on Sunday.
In the school campus, my lord,
So as-
there are many teachers, primary schools are,
So as any official act has to be on working day. That just for a glance we have seen. In that case, all officers can transfer posting. Cabinet decision can be on Sunday, but order has to be on only on working day. Rules of executive business. As a lawyer, you must read.
my lord.
That is the reason. For two reasons, this document was not placed before the trial. So you had it because this is a document of 2015. You have said you are born and brought up at Tripura. And secondly, this document was issued on Sunday.
My lord, the statement was wrong, my lord. She was born, my lord. Born and
Yes, Mr. Pine. If it is, there is no statement in the written statement. What will happen?
Lord, we have numbers of judgment that, my lord, the pleadings has to be there in the paper.
There has to be pleadings.
Yes, my lord. Pleading,
Then
whatever pleaded, my lord, those has to be proved in the evidence. So here in this case, my lord,
procedure has proved. Don't you think so? By producing the quota list of 1993.
93, my lord, it is not proved, my lord. 93 cannot be.
Why?
Please. 90. 93 quota
They
list, my
have
lord.
produced one relief eligibility certificate issued in the name of one Har Kishore Das Talukdar.
First of all, my lord, there are first issue, my lord, your lordship will have to see the notice was issued in the name of my lord. Lordship will find notice is there, my lord. Notice was issued in the name of Dipali Rita Rani Das, my lord.
Hmm.
And she was designated as daughter of my lord Pramod Ranjan Talukdar
That's right.
and wife of Kripesh Das.
Hmm.
And in the entire case, my lord, she is trying to prove herself to be daughter of my lord Kishore, Hara Kishore Das Talukdar. And there is, to that effect, there is a statement that Hara Kishore Das Talukdar and this my lord
Pramod Ranjan Talukdar.
Pramod Ranjan Talukdar is same person. But there is no evidence to that effect. It is not the case that she has denied that I am not the mother, I am not the mother proceeding.
That notice,
Notice your lordship will find that case my lord. Even in my lord judgment opinion also is described as Rita Rani Das, daughter of late Pramod Ranjan Talukdar, wife of Kripesh Das of village Notun Ramnagar, Parpan. Page 38, my lord. Notice page 32, my lord. There are two issues, my lord. First of all, Rita Rani Das and Dipali Rani Das. The notice and the proceeding, my lord, was against Rita Rani Das, wife of Kripesh Das, who is identified as daughter of Pramod Ranjan Talukdar. She is trying to, my lord, link herself with one Hara Krishna Kishore Das Talukdar and identifying herself to be Dipali Rani Das. That is the case here. And that is also not absolutely proved. There is a certificate in the name of one Horo Kishore Das, my lord, that is relief eligibility certificate. And the voter list of 1993, which the petitioner is relying, that is in the name of Dipali Rani Das, who is identified to be daughter of Har Kishore Das at village Ambikapur.
Yes. In your cross, you have accepted that you are the Pramod Ranjan Talukar. Where is the document? Could have.
One in petition, my lord, I have stated, my lord, that the notice was issued in that regard, that is why it pays 6, my lord,
You have accepted.
para 7, my lord.
The notice was issued in the name of Pramod Ranjan Talukar, daughter of Pramod Ranjan Talukar, wife of Kripesh Das,
Kripesh. Kripesh is my husband, my lord.
right?
Yes, my lord.
So in your written statement, there is nothing.
Silent.
I am not the daughter of Pramod Ranjan Talukar. I am a daughter of
Daughter.
Har
But he has
Kishore
written,
Talukar.
only Harkishore Das is written, my lord.
But
It
you are
is not
saying
written that he is the
your
daughter.
case is you are a daughter of Haro Kishore Das.
Harkishore Das, yes.
You are not daughter of Har Kishore. You are a daughter of Haro Kishore Das. So
And my lord, school certificate is also annexed, my lord.
your school certificate have not been
Exhibited, it
exhibited.
is not exhibited, my lord, but it was annexed, my lord, with the written statement, my lord.
That is the reason we ask you in your cross examination. You have clearly stated you have gone and brought up at Tripura. What is the question of giving a school certificate from Kachar Silchar?
He was born by that, my lord, but not born.
That is your statement. We have not developed anyway. Nor you,
My lord.
right? You have to go by whatever the procedure says. Can you go beyond that?
No, my lord.
Here, my lord, from WS, your lordship will find. Para 7, my lord. WS para 7, page 33, my lord. The OP's true and correct name is Dipali Rani Das. they, my lord, the notice was served as Rita Rani Das, daughter of, my lord, the
Pramod Ranjan Talukdar.
Pramod Ranjan Talukdar. Here she has the true and correct name is Dipali Rani Das, daughter of that Horak Kishore Das, which she used to write before her marriage, but after her marriage, OP changed her name as Rita Rani Das. The title can be changed, the name can be changed, madam. Rita Rani Das, wife of Kripes.
See, even
Xerox-
if it is.
Even it is, madam, the father name is also different. No.
It is Haro Kishore Das. And that 1964
Yes.
relief eligibility certificate was issued in the name of one Haro Kishore Das Talukdar.
Madam, even though we accept that Horak Kishore and Har Kishore is same person, can we accept that Har Kishore and Pramod Talukdar is the same person? So entire case, madam, in the entire case, your lordship will find this is a matter case where the Rita Rani Das, daughter of Pramod Ranjan Talukdar, trying hard to be madam proof as daughter of Hara Kishore Das, as Dipali Rani Das. Even her name has been changed. Her father name has been changed, madam. For that purpose. In fact, there can be one Hara Kishore Das, my lord, and one Dipali Das could be the, my lord, relative of that Hara Kishore Das. But there is no document at all in the name of Rita Rani Das. Prior to the, my lord, filing of WS, there is no documents at all Rita Rani Das and, my lord, the Pramod Ranjan Talukdar. So the Rita Rani Das, who is daughter of Pramod Ranjan Talukdar, trying herself to be proved, my lord, project herself to be proved, my lord, as Dipali Rani Das, daughter of Har Kishore Das somehow. And in that case also she failed. In that case also she failed. But in the entire case, my lord, she is not Dipali Rani Das. Neither she is daughter of Har Kishore Das. That's why the, my lord, in entire case, in some cases she has said, my lord, she is brought up. Because the record says something others. And actual fact is something others. So the both in the WS as well as in the evidence, the all things are not contradictory to each other. In some cases, she is saying probably the first issue is correct. She is Rita Rani Das, daughter of Pramod Ranjan Talukdar, and probably she was she migrated from East Pakistan and she was residing there in Tripura. That may be the correct story. But to project herself to be daughter of, because herself to be Dipali Rani Das, daughter of Horak Kishore Das, she has taken some falsehood. And this can be ascertained from the certificate also, school certificate, page 31. Because school certificate is given in the name of Dipali Rani Das and Har Kishore Das Talukdar. The projected father and projected name. Page 31.
Pharma. Affidavit on call for relay.
No, Tariq. 9/11.
Okay, we pass order.
My lord.
What's your good name?
Hey, how are you, my lord?
Hey, how are you? Yeah. P. Sharma. Common advocate Assam for West. And Mr. A.I. All to you. Yes, Mr. Sharma, you have the instruction whether the petitioner appears in item number 3 or not.
Item number 3.
Yes, Lordship, petitioner appeared before the concerned SP on 18/3/2017.
18/3/2017, for the order.
Yes, Lord.
May I please, your lordship? Lordship, my senior counsel is on his legs in code number 18. The matter was fixed at 2:30.
You have other counsel to start? To start? Let us know if
Mr. M.O. Mahmood.
true, there are other counsel. We'll hear Mr. Mahmood later.
Okay.
To place the facts of the, what is the case of, you place the.
My lord, the defect of the case is that the petitioner was born and brought up at village Hatif Muria. Then,
Where from you are saying that?
sir, from the synopsis.
Sorry, my lord. Extremely sorry. So many. Tell it, yeah, two another case was in code number 18. Now, lordship may kindly see the impugn order, page 30. Here, lordship would kindly say some documents which I have exhibited. Those documents, page 32. Page 32. Exhibit Co is the copy of periodic Hiras Patta of 1957, having the name of Nur Muhammad, son of Umed. So, this Umed name is written, I don't know how the learned tribunal has written. Actually, his name should be Usman. And for instance, my lord, kindly see page 22. So, this is the proof that the learned tribunal did not apply its judicial mind. So, Nur Muhammad, son of Umed, whereas document says, page 22, kindly see, Nur Muhammad, son of Usman. So that is one example. Second thing, lordship, kindly see, Exhibit Kho is a sell deed of buying land by O.P. Halima in the year 1985. Now, lordship, I draw your lordship attention. My father died during the year 1954-55. So that is very important. 54-55, when I was a girl of about 2 or 3 years, I think 2 or 3 years. At that time, my father died. So I could not collect the voter list of my parents of that year, 66 or there. But the linkage is there because my name is there with my father. That is, that lordship may kindly see page 20 and 22. Page 20, this is the English translation. Operative vernacular is page 21. Halima Khatun, Abhibhabak Nur Muhammad. Nur Muhammad is my father. In the order, my lord, right side, your lordship would see, Sorojamin Chithar Chakro Bikhayar 11-10-99 তারিখর হুকুম মতে উত্তরাধিকার সূত্রে 1 নম্বর স্থলত 4 নম্বর হালিমা খাতুনের নামে ওই তারিখর হুকুম মতে খরিদা সূত্রে 4 নম্বর স্থলত 2 নম্বর আজিম মোহাম্মদের নামজারি হয়. First thing, my name has been recorded by virtue of inheritance. And that lordship would see serial number 4 Halima Khatun, Abhibhabak Pita Nur Muhammad. 2 নম্বর, 3 নম্বর, 4 নম্বর, 5 নম্বর, 6 নম্বর, 7 নম্বর, 8 নম্বর, 9 নম্বর, 10 নম্বর, 11 নম্বর, 12 নম্বর, 13 নম্বর, 14 নম্বর, 15 নম্বর, 16 নম্বর, 17 নম্বর, 18 নম্বর, 19 নম্বর, 20 নম্বর, 21 নম্বর, 22 নম্বর, 23 নম্বর, 24 নম্বর, 25 নম্বর, 26 নম্বর, 27 নম্বর, 28 নম্বর, 29 নম্বর, 30 নম্বর, 31 নম্বর, 32 নম্বর, 33 নম্বর, 34 নম্বর, 35 নম্বর, 36 নম্বর, 37 নম্বর, 38 নম্বর, 39 নম্বর, 40 নম্বর, 41 নম্বর, 42 নম্বর, 43 নম্বর, 44 নম্বর, 45 নম্বর, 46 নম্বর, 47 নম্বর, 48 নম্বর, 49 নম্বর, 50 নম্বর, 51 নম্বর, 52 নম্বর, 53 So this is the strong linkage. And this is exhibited before the learned tribunal. Exhibit Jha. Lordship has seen. So this is very important linkage with my father. Now, Lordship can see the other documents which I have exhibited with the learned tribunal, that is exhibit page 32. I am again inviting your lordships to page 32. Exhibit Go is the certified voter list of 1975 having name of Halimun Nessa. So these are the voter list with my husband. With my husband. So all these things are these are of village, same village. These are same village. That village name is Hatimuria. Hatimuria. So all these documents are of village Hatimuria, along with my husband's name, because my father died when I was a child of 2-3 years. So another document Lordship would see, page 22 linkage with my father, and Nur Mahmud, that is number 3, vernacular, Halima Khatun, Abhibhavak Pita Nur Muhammad. And the right side it is written that Sorojamin Chithar Chakrabikhayar, same date, Hukum Mote Uttoradhikar Hutre, 1 number Sthalat. 1 number means Nur Muhammad. Nur Muhammad, Nur Muhammad. He is my father. So, Uttoradhikar Hutre, 1 number Sthalat, 3 number Halima Khatuner Name, Namdari Kora. So, these are the two documents. One is 22, another is 21. These are land documents. And Lordship is aware that the Namjaris mutations are done as per the provision of Assam Land and Revenue Regulation on the basis of mainly possession. So, though my father died, but land was in our possession. And it was duly verified by the Latmanda and came to finding that Nur Muhammad, alias Nur Mahmud, are her father, and accordingly her name was recorded in the land document. So for disputes in the names, my lord, I have shown an affidavit. Affidavit that Lordship may kindly see page, exhibit job, page. My lord, may kindly see 26. Evidence, affidavit, affidavit. File of us. It is in file, my lord. That affidavit has been marked as exhibit job. Kindly see it is in record, my lord. And that was exhibited. And the contents of that affidavit was that in some places, my name is as Halima Khatun or Halimun Nessa, and father's name Nur Mahmud or Nur Muhammad. That was exhibited without any objection from the other side. And Lordship, your Lordships are aware, that is 2013, 1 GLT, page 941.
Please repeat.
2013, 1 GLT, page 941, para 9 and 10. Here our High Court said that when the documents are exhibited and the contents remained unchallenged, that should be accepted as evidence, as legal evidence. So the affidavit has been exhibited as jaw. So that was exhibited document. And other exhibited documents, Lordship, all voter lists with my husband, Hatimuria exhibit Go, is the voter list of 1975. 1975, Lordship, that is page 14 of the record. That is exhibited document. Then my Lord, 77 voter list, this is exhibit Gho, page 16. And 89 voter list, page 18, exhibit Ungo. And Jamabandi, I have already submitted it before your Lordship. These are the linkage documents, that is exhibit Jha and Nia, page 21 and 22. And government Gaura certificate that was exhibited, page 23 and 24, and that is exhibit Shaw, page 23 and 24. But this government Gaura, my Lord, was not examined. And that is the perhaps wrong advice of the learned counsel who conducted the case. He should have been examined. But even then, his certificate has been exhibited, and there was no vital objection to that effect. Now, there is another non-application of mine, of my Lord Learned Tribunal, that Lordship may kindly see page 33 and 34. Kindly see page 33 and 34. Here, the third para number is not written, but third para, OP has stated in deposition that the name of our mother is Mihiri Khatun and Mihiri Khatun. So this is wrong, my Lord. My mother's name is Meherun Nessa. This Mihiri Khatun is unknown to me, but the Learned Tribunal note like this. My mother's name is Meherun Nessa. So this Mihiri Khatun is written, perhaps it is also an example that the Learned Tribunal did not apply its judicial mind to the documents which were exhibited. So far, differences in adjacent names, affidavit I have submitted, and I have also stated that all these things in written statement. If your Lordship kindly see written statement may be seen in the record. It is not exhibited, but it is in record, my Lord. At that time, it was not brought. So, Lordship may kindly see in written statement. Yes, written statement, Lordship would see para 6 onward. Can you see? Written statement para 6 onwards. অপরপক্ষর পিতৃ 1955 সনত অপরপক্ষক একমাত্র ছোৱালী এৰি থৈ মৃত্যু হয় তাৰ পিছত অপৰপক্ষক খুৰাক আব্দুল আজিজে লালন পালন কৰি ডাঙৰ দীঘল কৰি তাইক বিয়া দিয়ে অপৰপক্ষ ভোটাধিকাৰ পোৱাৰ উপযুক্ত বয়স নোহোৱাৰ কাৰণে অপৰপক্ষৰ নাম 1965 ও 70 চনৰ ভোটাৰ তালিকাত তালিকাভুক্ত নোহোৱা হেতুকে বিয়াৰ পাছত তাইৰ স্বামীৰ অসম বিধানসভা 83 নম্বৰ থিং সমষ্টিৰ 1975 চনৰ ভোটাৰ তালিকাত খণ্ড নম্বৰ 86 ক্ৰমিক নম্বৰ 102 আৰু ঘৰ নম্বৰ 234 উল্লেখ আছে উক্ত ভোটাৰ তালিকাত অপৰপক্ষৰ স্বামীৰ নাম আব্দুল আলীৰ ঠাইত আলী বুলি লিখা আছে কিন্তু আব্দুল আলী আৰু আলী একজন ব্যক্তি হয় অপৰপক্ষই 1974 চনৰ শহুৰৰ পৰা কিনি লোৱা মাটিৰ দলিলত মোছাম্মদ হালিমুন নেছাৰ পৰিৱৰ্তে মোছাম্মদ হালিম নেছা বুলি ভুলকৈ উল্লেখ আছে আৰু দলিলখনত অপৰপক্ষৰ স্বামী মোহাম্মদ আব্দুল আলী আৰু তাইৰ শহুৰ তমিজুদ্দিনৰ নাম উল্লেখ আছে So husband's name is there. Then para 10 Lordship would say অপরপক্ষর নিজর নাম মোসাম্মদ হালিমুন নেছার পরিবর্তে হালিমা আর স্বামীর নাম মোহাম্মদ আব্দুল আলীর পরিবর্তে আলী বলে অসম বিধানসভার 83 নম্বৰ থিং সমষ্টিৰ 1989 চনৰ ভোটাৰ তালিকাত খণ্ড নম্বৰ 73 ক্ৰমিক নম্বৰ ক্ৰমে 616 আৰু 615 আৰু ঘৰ নম্বৰ 120 আছে কিন্তু ভোটাৰ তালিকাত অপরপক্ষর স্বামীর পিতৃৰ নাম তমিজুদ্দিনের পরিবর্তে তমিজ বুলি উল্লেখ আছে অপরপক্ষর লগতে তাইৰ পিতৃ আৰু অন্যান্য পৰিয়ালৰ লোকৰ নাম 1951 চনৰ এনআৰচিত উল্লেখ আছে যদিও বৰ্তমান 1951 চনৰ এনআৰচি প্ৰত্যায়িত নকল সংশ্লিষ্ট কাৰ্যালয়ৰ পৰা আবেদন যোগান নধৰাৰ হেতু দাখিল কৰিব পৰা নাই যদিও এই চনৰ এনআৰচিৰ লিগেসি ডাটা কপি কাটি দিয়া হ'ল So Lordship would say, I understand that there is some problem that she could not adduce the evidence of her parents. First, parents died when she was 2-3 years old. On the other hand, mother also, at present, mother is also not there. So her two uncles adduce evidence. Those two uncles' names, Lordship, Abdul Jalal and Abdul Jalil. DW1. Sorry, DW2 and 3. DW2 and 3. That may be seen in record by Lord. Is not brought earlier. So, and the DW2, his her one uncle, DW2, that is Abdul Jalil. But uncle in that sense, my lord, not directly the brother of father. Their uncle, in a sense, that Nur Muhammad is the son of Usman. Abdul Jalil, DW2 is the son of late Asmat Ali. And Abdul Jalal, DW3 is son of late Ashraf Ali. Nur Muhammad, Abdul Jalil and Abdul Jalal are cousin brothers. In this way, I am niche of these two PWs. Because her uncles also died. Own uncles have also died. She is now about 70 years of age, 64 at that time. So the parents died, uncles died, and not distantly, blood connected. These two uncles came and they adduced evidence to the effect that I may read, my lord. It was also, they are also cross-examined by the other side. First, my lord, I am reading DW টু আব্দুল জলিল জি কম হসা কম অপরপক্ষ মোর ভাতিজি অপরপক্ষ নূর মোহাম্মদর ছোৱালী নূর মোহাম্মদ মোর বৰদেউতাৰ ল'ৰা অপৰপক্ষৰ জন্ম মোৰ ঘৰতে অপৰপক্ষৰ বয়স ৬৬-৬৭ মান হ'ব এনআৰচিত তাৰিখৰ নামত এনআৰচিত তোৰ তাৰিখৰ নামো আছে এনআৰচিৰ চাৰ্টিফিকেট কপি দিব পৰা নাই অপৰপক্ষৰ দেউতা অনুমান 1954-55 মানত ঢুকাইছে অপৰপক্ষৰ মাকৰ নাম মেহেৰুন নেছা and the learned tribunal মাহিৰী মেহেৰুনৰ দ্বিতীয় বিবাহ হৈছে মই শুনামতে মেহেৰুন দ্বিতীয় পক্ষৰ জালালুদ্দিন বুলি ল'ৰা এটা আছে তেওঁৰো মৃত্যু হৈছে অপৰপক্ষৰ দেউতাৰ নামত মেহদি খেৰাজী পাট্টাৰ মাটি আছে 1957 চনৰ পদক্ষ ক মেদি মাটি মেদি খেৰাজী পট্টা পদক্ষ খ অ শাখাক শাহুক আৰু শহুৰেকে দিয়া মাটিৰ দলিল অপৰপক্ষৰ একে গাঁৱৰে অৰ্থাৎ হাতীমুনিয়াৰ তমিজুদ্দিনৰ ল'ৰা আব্দুল আলীৰ লগত পদক্ষ গ 1975 চনৰ অপৰপক্ষৰ নামে থকা ভোটাৰ তালিকা পদক্ষ খ দিছ আৰ দ্য ভোটাৰ লিষ্ট he is also exhibiting which were exhibited by Halima that is the proceeding হাতীমুৰিয়া অপৰপক্ষক ডাঙৰ দীঘল হয় অপৰপক্ষক বিদেশী নহয় so to court and this is the cross pilot to continue অপৰপক্ষক 18-19 বছৰ বয়সত বিয়া হয় অপৰপক্ষৰ দেউতাকৰ মেদি মাটি আছে so it was asked by court but it was asked by court so what is the difference my lord court said to court asked her question she said অপরপক্ষ 18-19 বছর বয়সত বিয়া হয় অপরপক্ষ দেউতাকৰ মেদি মাটি আছে so my lord otherwise the court's question has
Let us do like this. As per the written statement, how old are you? It was filed on April 2016.
Yes.
So in your evidence, what you have stated?
In my evidence?
You have filed your affidavit, right? Along with the verification, you have not filed your affidavit.
Yes, I have filed my affidavit.
Where is that?
That lordship could not annex, but it is maybe in LCR, my lord. Here,
It's not
I have,
here also.
I have, no, it is exhibited document, my lord.
It's not there in the affidavit. The affidavit is not along with the written statement. That's why you're asking.
No, lordship, then lordship kindly come to page 32. Page 32, page 33 kindly say.
Verification is there, but no age.
Exhibit Joy is an affidavit. It is written by tribunal. Page 33. Exhibit Joy is an affidavit sworn in by OP in respect of the name, discrepancy of OP, but affidavit is not considered as an evidence under the evidence act. That is not correct, man. As per section 276 CRPC, perhaps. This evidence affidavit is maybe treated as evidence, as the formal proof. So this finding is not correct.
Why?
Yes, because CRPC has given the evidence a formal character. Affidavit is a formal character of proof.
Which section?
Most probably 286 CRPC.
Exhibit, sir?
That is exhibit Joe. J.
Exhibit Joe, copy of Jamabandi as exhibit Joe. GSA.
Then tribunal has written wrongly. You see this? Exhibit judge and affidavit. J.
Yes. Affidavit shown by OP in respect of the name of discrepancies.
Yes.
This is an affidavit filed for the purpose of name corrections.
Yes.
This is not, this
Mr.
is,
Pang, let him complete.
no, just I'm clarifying my lord to my honored senior friend. He's in confusion probably.
Yes, Lordship, 296, section 296 of CRPC.
Hmm.
Evidence of character on affidavit. And this interpretation may be also seen. The judgments in this regard, there is, I have argued in many other cases also,
Hmm.
that affidavit is subject to cross-examination. Now, whether it is cross-examined or not, so far I see there is, as there is no affidavit, I do not see any cross-examination. Anything is, if a question is raised, that is raised by the tribunal. In some cases, this case I see,
Please come to paragraph number 6 of your written statement.
yes.
Kindly read.
অপপক্ষৰ পিতৃ 1955 চনত অপৰপক্ষক একমাত্ৰ ছোৱালী এৰি থৈ মৃত্যু হয়। তাৰ পিছত অপৰপক্ষক খুৰাক আব্দুল আজিজে লালন পালন কৰি ডাঙৰ দীঘল কৰি তাইক বিয়া দিয়ে।
Very good. Now your KP Patta.
Yes, KP Patta.
Come below. It's an exhibit, right?
Yes, exhibit.
It was issued when?
It was issued. That may be. It is issued, my lord, on 11/10/99. As per the order, page 21 of the writ petition.
That you have purchased.
No, by dint of inheritance. Page 21, top, right side. সরজমিন চিঠার চক্র বিষয়ার 11/10/99 তারিখে হুকুম মতে উত্তরাধিকার সূত্রে 1 নম্বর স্থলত হালিমা খাতুনের নামে ওই তারিখের হুকুম মতে ফরিদা দখল সূত্রে 4 নম্বর স্থলত আজি মোহাম্মদ। That means I was the owner, but I have sold to Aji Muhammad. But relation is established. Though my father died in the year 1955 or 54, but he had land, and I have owned that land.
Kindly see exhibit co.
Exhibit co. Let me focus here.
What is exhibit co?
Exhibit co is the periodic part of 1957.
Of 1957.
Yes.
It is a very specific plea that your father expired in 1955. And a periodic patta has been issued to deceased father in the year 1957.
That may be
possible.
That may be.
That is possible.
Possible.
Very much.
Because
which
my lord,
provisions of law can you tell us?
let
That
me
periodic patta can be issued
No,
in the
but
name of a
can you-
deceased man, a dead person.
yes, madam. I'm saying your lordship. Actiona patta, if in the name of one person, government takes the same some premium, and after premium is paid,
Mr.
there are
Mahmood,
some
so
processes.
very specific provision of law that periodic patta can be issued in the name of a deceased person.
No, deceased means when it was processed at that time he was living.
It was issued as per the exhibit of what we have seen here. It was issued on 13th of December 1957. Furthermore, revenue was assessed prior to that on 30th of November 1957. So kindly tell us under which provisions of law a periodic patta can be issued in the name of a deceased person.
That is definitely under the provision of Assam Land and Revenue Regulation 1886.
Can you show us?
Now, on that regard, my lord, yes, I may show, citation, no problem. But one thing I am submitting at present, my lord, I have not brought the citation, but lordship, for my own learning, I am telling that if a person has an annual patta land, an annual patta land is converted into periodic patta, subject to payment of premium. Now, when my father was alive, the government processed that this Akshona patta land may be converted into periodic patta. But before the completion of the process, he died. Even after that, his name would come there, and thereafter his legal heirs would come. In Guwahati, lordship would see some persons purchase the annual patta land only possession, and thereafter the government makes the land Meadi. But Meadi patta is made in the name of that person who sold it. Thereafter, that person will execute a deed in the name of the person to whom he sold the possession, he will get only. Though I am possessing the land, but I will not get the patta. Patta will be issued in the name of the original Akshona patta holder. So these are, my lord, common things going on. This lordship may believe this.
Prior to, see, if you are saying about annual patta.
Yeah.
Then how annual patta can be considered?
No, annual.
Law is well settled. Every year you have to file application before the deputy commissioner.
No, annual
It has to be
patta.
considered.
Annual patta creates right, it can be also sold. Annual patta land can be sold.
Only when you are settled it for annually. Right.
A annual patta holder can sell
Okay,
his land.
You will show us the provisions tomorrow.
Yes,
or day
definitely I may show. But lordship may kindly grant me some time. Annual
after- day
patta
after
land,
tomorrow, Day after tomorrow.
Yeah.
Day after.
annual patta
Yes,
sell
then
is
proceed.
sellable.
Then-
Annual patta holder is.
Now,
has a-
as per your affidavit,
My lord.
you are relying upon your NRC of 1951. Right.
NRC legacy data.
It is there. You have a next. Also an exhibit, I believe.
NRC legacy data exhibits. That is not exhibited. Para 11, lordship may kindly see. It is not exhibited, but the statement is there, my lord. Para 11, my lord. Para 11 of my WS, and that is not challenged by them. Para 11 of my WS. And moreover, my lord, NRC is not the proof of citizenship. So that may not be given so much value. But legacy data otherwise, it a corroborative piece of evidence that my father was available in the land of Assam during the year 1951. At least that is proved. Otherwise, a government officer cannot record my name if I am not present here. So, if even I produce the NRC of 1951, that would not be so much helpful in this case, because as per section 15 of Census Act, NRC is not the proof of citizenship. Position लिखियो, तो ruling position है। It is ruling anymore. That annual patta land can be sold. It is sellable right. It gives right title interest, but some restrictions are there. Some restrictions are there. Otherwise, it can be sold. So, even if we say that Khiraji patta is for a moment we have kept aside, even then my father's name is recorded in that land, and I will get that benefit.
Chamber filter light, chamber filter.
Okay, we'll continue on day after tomorrow.
Obliged.